But I'm gonna need an interpreter.
Okay.
Mr. Longmaker.
Mhm. All right. Well, Max still needs to be here. But Sean, today is Tuesday, so they tell me we survived Monday. I still don't know that the issue with the zombies and why we are third. But I'm only concerned about my mom. Where is Louisiana ranked? Yeah, I'm going to find the article. All right, everyone, I'm going to call the docket. Everyone, please have a seat. If you do not answer, I'm going to assume you are not here. And a warrant may be issued for your arrest. In custody, we have Melvin Owens, Jesse Heno. Thank you. In custody, we have Alexander Williams, Fidel Ayala. Fidel, thank you. Rolando Gutierrez Chavez.
Present with counsel, Your Honor, I'd like to urge a trial motion with an interpreter.
All right. Christopher Gonzalez. Christopher Gonzalez. Juan Tehran. Brandon Sierra. Leonardo Rosales. Andy Maldonado is in custody. Martin Lee Rios. Joaquin Mendez. Okay. Carlo Madrigal. Carlo Madrigal Hernandez. In custody is Todd Dotson. Eric Diaz. Eric Diaz. Dennis Martinez. In custody is Luis Ramirez Rodriguez. Edgar Aguilar. Alberto Soto. Briala Butler. Briala Butler. In custody is Esteban Ramirez, Eddie Alvarez, Chase Gordon. All right, is there anyone who came in late or your name was not called? All right, we'll start over here on the back row. What's your name? First name? Do you know your case number or SID number? Do you know who your attorney is? All right, just have a seat. We're going to take that matter up. Anyone else over here? Yes, what's your name? Do you know your case number or SID number? Do you know who your attorney is? All right, how old are you? All right, you're in felony court. This is a very serious matter. It's very important that you know who your attorney is. You understand? All right, just have a seat. We'll get with you. Anyone else over here? Over here, yes. Do you know your case number or SID number? Do you know who your attorney is? Carrillo? Yes. Thank you. See, everybody, that's how it's done. She knows this is important. But Bashan, I don't know if I'm being sort of biased when I say this, but women always know their business. They know who their attorney is. They know their SID number. They know everything. So guys, you need to be more like that, okay? Anyone else? Robert Featherston knows what I'm saying is true. Yes. All right, thank you. Why were you late? Okay, all right, thank you. You can remove yourself from the front row. Yes. All right, everyone. We are starting up with closing arguments with the trial at 10 a.m. So all of you who have your trial setting today, rest assured you are going to trial this week. So that's not going to be a problem whatsoever. In the 187th, we are, of course, a court that tries cases. So to my left, those are the criminal trial division files. To my right, that's family violence files. As y'all know, there's an uptick in COVID, an uptick in leprosy. So just grab your file and place it on the corresponding table, have a seat. The prosecutors will call you in the order in which they receive your file. If you have someone who is in custody, yes, they need to be called out. Let the deputy know. Where the deputies are standing, attorneys, you know that's the door where the inmates come from. Please keep that area clear so they can have a line of vision. If you choose not to do so and something were to happen, I've already given them permission to do whatever they need to do, including perhaps run over attorneys for the safety of the court. So that will be on you if that happens and they can't see. To the back here is the CLO. Could you raise your hand? That's Miss Abrams. That is her desk. Do not put your items on her desk. Do not hover around her desk. That's her office. She doesn't have any walls. Do not turn your back to her. Here is the court reporter. All of that equipment you see up there, that equipment costs $10,000. If you touch it, if you disturb it, if you damage it, you have bought it. I will come to court as a witness saying that you destroyed that equipment and you will be on the hook for $10,000. Today is Tuesday. It's not Monday. We survived, so we should all be excited about that. We're going to confer kindly with each other. We are not going to approach the court coordinator for a reset or continuance because I'm the only person who can give that to you. We are not going to approach the court until we confer it with the state and confer it with our clients. So everyone, let's have a beautiful Tuesday. Please confer.
Yes, she has good.
All right. And Kenneth Longacre is zooming in and he has cases that, what is a 605? What is a 605?
And Lorraine Efron is the federal attorney on those cases.
All right. So why is it labeled 605?
That's typically what it is, Judge, but that might be my mistake.
All right. Because some of the criminal trial division, it doesn't have a 605 number attached to it.
That's actually
All right. We're going to discover the answer to that.
Criminal trial division, drug cases.
Mhm. All right. So I'm going to send you to breakout room. Are you available to go to a breakout room with Mr. Longacre? Is that your case or no?
I think Judge, it is Kenton Longacre. I don't know why I don't see myself. I hear you, I see you, but I don't.
I see you too, Mr. Longacre. Just give us a second.
Okay.
All right. So he has a deadly conduct firearm case and also a possession 4 grams. It may be 4 to 200. It got cut off.
It is.
All right. I'll send you all to breakout room number 1.
Thank you.
Hello, Mr. DeLeon.
Good morning, Your Honor.
How are you doing today?
I'm good.
It's always great to see you. Don't be a stranger.
Ah, I got other questions to go to, but I figured we'll start with the best one
Look at you.
first.
Hey, I appreciate you starting in the 187.
Absolutely. I got 2 things this morning, Judge.
Mhm.
One on docket. Christopher Gonzalez.
Mhm.
We were here Thursday. I filed a motion for continuance for today.
Yes.
So the court said they would grant the continuance, but I don't know if it's printed out in the file yet or not.
All right. If you'll let them know.
Okay. And then completely different matter, Judge, off docket. There is a nice lady who hired our firm for $200,
Mhm.
a lot of money.
Yeah.
For injury to the elderly. Her daughter has been locked up for almost a year.
All right. Just 1 second. And Norma, for those people who announced who think they're on the docket today, if they haven't seen their attorneys, get their attorneys here today so they can see their attorneys. Yes.
Okay, thank you. Anyways, she's incompetent. I'm gonna have her reevaluated,
Okay.
but I'm also getting off the case. I'm doing motion to withdraw, but I do want to get court appointed onto that case.
All right. Because $200. Yeah. No, I understand.
Nobody else knows anything about it. And yeah, the family is just,
All right. If you have them pull the file, and we can take that matter up today.
I'll work on that. Thank you, Judge.
You're welcome. But that was nice of your firm to get on a case for $200 to help her.
We wanted more. They just didn't pay.
Yeah.
Yeah. Yes. Yes. Thank you so much. Yeah, that's it. If you say so.
Yeah.
All right, why do people keep going to Yellowstone and playing around with the bison?
They're so cute.
Mhm. All right, is Christopher Gonzalez, he is on the docket. Did I say he was not to appear today?
Said he was not. there.
Okay, I just wanted to be certain of that. Let me check the docket, because I would have wrote it here on the docket.
Yes. Okay.
Oh, no. Okay, I remember now because he works.
I'm gonna give him a call. Your other hand?
I think.
Family violence? Can I see someone from family violence?
All right.
All right, Mr. DeLeon is on Christopher Gonzalez. He was recently appointed because the person had a previous attorney. And Mr. DeLeon still has matters that he needs to look into. I did excuse his client from appearing today because I told, I believe Brittany Mitchell and Mr. DeLeon that I would grant the motion for continuance, but he needed to file a motion today.
Yes, Judge, I don't think we'll have any objections to this motion.
All right. Norma, we'll get you a reset date for trial. How long are you all expecting this trial to last? Well, Michael, what do you think?
It's a 3-day trial.
I'm sorry?
Sounds great, Judge.
It's a 3-day trial.
Okay.
Unless Mr. wants to. File the motions.
Norma, I need a jury trial setting on Christopher Gonzalez. Christopher Gonzalez, jury trial setting, 3 days. And it's family violence. 2022 CR 10364. All right, we're coming back. Yes. We're coming back on October 30th.
And he'll go to impact.
Joy.
All right, we'll see you in impact. Well, I won't see you. Another judge will see you in impact.
Thank you, Judge.
You're welcome. All right, Lorraine,
Yes, Your Honor.
with regards to your client, Mr. Escobar has the breakout room number.
Okay. Can we, I guess we'll go in the back?
You all can go either in my chambers or either in the back area.
Okay. I will head back there now.
All right, thank you. All right, I just want to let you know, I sent you and Marcus' Zoom link. Okay, I'll send it again. Okay,
Yeah, I was gonna look at that. That's the first time.
all right, thank you. Bye.
We didn't have to look at the file ever.
Yeah, I was saying that.
Oh.
It's so hard. I see what I don't know.
We call you Banksy.
I have to reach.
Anyone?
Dennis, Brian Martinez. Your client needs to come forward. Hello,
Hello.
you're on this side. Who's the prosecutor on Dennis Brian Martinez? It's driving while intoxicated, third or more. Hello,
Hey, good morning, Judge.
good morning. So where are we on the blood discovery?
It's Brett Discovery, Judge.
Oh,
And
I don't know why it's listed in here as blood. So where are we on that?
Judge, we were told today that a signed order by you has not been done yet. The order's been submitted, but it has not been signed by yourself, Your Honor.
No, I sign everything that's placed before me. So if something hasn't been signed, it's because nothing has been submitted to the court.
Okay, well, that was done back on June 26th, Judge. We filed a motion.
It's not in the file.
Okay.
All right. So defense attorneys, when you have motions, please approach the court with your motions. Don't just file them and then, oh, well, they're done.
We apologize, Judge.
No problem.
We're here. I believe you had told me the same thing, that you had signed the order. And then the state checked yesterday and they were saying we don't have a signed order yet.
Yeah, because I don't have the order.
Okay. I apologize, Your
No
Honor.
problem.
But I will find the order, Judge, and bring it to the court's attention.
Oh, no. We're getting it done before 10 today.
Okay. I think she's getting it printed. Yeah, you know, this is fine. Sure.
Hi, Barbara. Just give me a moment. All right, your order has been signed.
Thank
So
you,
when is this going to be done?
Judge. I was told that as soon as they get that order, they can have it quickly. Again, I've been noticing it usually takes about 30 to 45 days.
All right, Ms. Ferguson, on Dennis Martinez, I need a 30-day reset for discovery.
Thank you very much, Your Honor.
Okay, sure.
And I apologize, Judge.
No problem. It's just that when a motion is filed, people are assuming that I receive it automatically. I do not.
Okay, well, I will make note of that.
All right, thank you.
Thank you very much.
What date? All right, he's excused once he signs the reset form.
Thank you very much. Your Honor.
You're
We
welcome.
Appreciate it.
And Jason, if you could have someone go to the breakout room with Barbara Paulison. And I believe Lorraine Efron is in the back chambers.
Okay.
And Barbara, I'm going to move you to breakout room number 2.
Okay, thank you, Judge.
Okay.
Annie Rivera.
Morning, Judge.
Good morning. So you're ready for jury trial, counsel?
Yes, we're ready, Judge.
All right, so this is going to be recalled for jury trial tomorrow. We're just finishing up this murder case, and that will be finished today. And so we will recall you for tomorrow.
9 a.m.
Yes, 9 a.m.
All right. Thanks.
You're welcome. Norma Maldonado Rivera is coming back tomorrow dressed for trial.
Gonna need an interpreter.
You'll have to ask the attorney, but I don't have it written on the file that he needs an interpreter. Melvin Owens. Good morning. Your client is in the center, sir.
Sorry.
All right. So you ready for jury trial?
Yes, sir.
All right, this is going to come back tomorrow for jury trial.
Thank you.
Do you have any questions, Mr. Owens? All right, we'll see you tomorrow for jury trial and they'll bring you over dressed.
Thank you.
Mr. Owens?
And Mr. Davidson, did you just confer with the state on an offer or no?
Yes, sir.
All right, thank you. Hello. Who's here on Chase Gordon? Yes.
See if I can grab it. They already sent it. Good morning, Judge.
Good morning.
Going to the elevator.
Okay.
What's happening with this case?
Yes, Judge, with regard to Mr. Gordon, he was ordered to DDRF approximately a month ago. Vashon did update us that he did not qualify because he does have seizures.
Mhm.
So I believe she was looking at some other avenues and SafeP may be a viable option, Judge.
That's the only other avenue, SafeP.
And I spoke with my client about it, about the program in detail, about the requirements, and he would very much like the opportunity for the court to order him to that treatment, Judge.
All right, so we'll do SafeP. Do you have any questions?
No, ma'am.
All right, we'll order SafeP then.
Thank you, Your Honor. Maybe excuse for this one?
Yes,
Appreciate it.
thank you. Norma? Mr. Longacre needs to appear in court. It's too difficult to do him by Zoom and everything else.
All I'm saying is that's.
one instance of something, we can talk about something like
And he's no longer on Zoom.
that specific instance. But that's not gonna.
Deputy Laura, is it hot in here? Is it me?
It's not.
Thank you, thank you. Deputy Laura, I'm going to take a brief break to make sure that they have their jury charge.
It's only first time.
Could you have her come in here, please? All right, Lorraine, you also have someone on the docket. It is Joaquin Mendez. It's the person who has the federal issue.
Oh, I'm actually not on his state case. I think Kenton Long
Yes.
Baker is. But I can tell you that his federal case is pending still.
All right, do you have a date or anything?
I do have a new court date for his federal case.
All right.
Your Honor, I have conferred with the district attorney. And I'm waiting to see what Lorraine has to say about that federal date.
All right. Just give us a moment. Could I see the parties on Rolando Gutierrez Chavez, please? Hello. Who is the prosecutor on this? It's an aggravated assault with a deadly weapon? Hi.
Travis Banks, the state of Texas.
All right. So my understanding, you're requesting jury trial?
Yes, Your Honor.
All right. State, how long you expect this trial to last?
State would expect this trial to last 2 days, including jury selection.
All right. And is your client a citizen?
He is, Your Honor.
All right. We're going to recall this for tomorrow for jury trial. You need to be here at 9 a.m. We're currently in a murder trial, but that trial will be concluded today, even if we're here till 1 a.m.
Hey, Your Honor, can go through this order for a speedy trial then?
Oh, your speedy trial is happening tomorrow.
Well, would I get the order signed just for my records?
Have you tendered it to the state for review?
I've conferred with them. They don't have any objection.
All right. Has it been filed?
It has been e-filed for a while.
Okay.
Yes, the state has no.
All right. Let me see the motion.
Want to see the motion and the order?
Well, I'll need the order in the motion.
A motion has a second page, just a signature page.
All right, this is incorrect on here. It says that there will be prejudice if trial is not had on or before today. So we're not having trial today. I'm not going to sign this today. We'll be in here tomorrow for a jury trial.
Well, I have other reasons for requesting the speedy trial, Judge. That's why I asked for a hearing. If I
No,
could-
what you put in your motion is that you want the trial today. We're currently in a jury trial today, so this trial will be tomorrow. So I'm not going to sign a document stating that your client will be prejudiced if his trial is not heard before today or today, because it's not getting heard today.
Then I just would like it on the record that I urged my motion for speedy trial.
All right, we
today.
can go on the record.
Okay.
Court is calling 2022 CR 10113, State of Texas versus Rolando Gutierrez Chavez. Can our parties announce for the record for the state?
Travis Banks, the state of Texas.
Defense?
JD Garza defending Mr. Rolando Chavez.
All right, defense has filed a motion for a speedy trial. State, have you had a chance to review the trial? I mean, his motion?
Yes, Your Honor, the state has had a chance to review the motion, and we have no objection other than to have the trial today would be an impossibility. But the state has no objection to the defendant having a speedy trial in this case.
All right, defense?
Your Honor, as the court knows, my client was arrested in January of 2022 for an offense that allegedly occurred on December 30th or 31st of 2021. And he is a truck driver, or was a hazmat operator for an 18-wheeler rig. His permit was pulled because of this accusation. And so he desperately needs to get on with his life, and that's why we requested a speedy trial. I understand that the court is in trial today, and we pray that we can start tomorrow.
All right, your jury trial will be scheduled for tomorrow. sign the reset form. We'll see you here tomorrow at 9 a.m.
Thank you, Your Honor.
All right, you're welcome. Just so everyone knows, we're starting up with closing arguments at 10 a.m. Anything that's not ready, you're gonna have to come back, and that's coming back before 11:45.
Can I approach you?
Yes.
I have an NTR, not set today, not set to Thursday. It's on a sex case, act sex case, Romeo and Juliet, 5-year age difference. Probation officer saying he can't live with his mom and bio siblings. I guess that had been done before. I have him here with his mother, but I don't know if I didn't do a motion, Judge. I was thinking of a B page or not. Also, I want him to be able to resume his program that he has to, but probation says you need to be the one that says it's okay.
All right, just one moment. Sorry about this. Hello? Oh, yes, I did. Thank you so much. I really appreciate it, Judge. Mhm. Mhm. Okay. Oh, all right. Thank you so much. Bye-bye. You'll need to have them pull the file.
I've got it on her desk.
Okay. All right, for Esteban Ramirez Frosto, we need an interpreter.
Okay.
All right. The parties on the jury trial. Here are the proposed jury charge. And be careful with this one because the staple is off.
Okay.
And if you could make sure that Diana receives one. All right. Esteban Frosto Ramirez.
We need a translator for this one, Judge.
Yes.
So one of the process you have.
And counsel, on this one, you have an immigration attorney, correct?
Not yet, Judge, but I do to get one. This is one of those, and I just wanted to warn you right now that we're ready to proceed to trial. So.
All right. Well,
I just need.
first of all, he needs an immigration attorney.
Sarah May, appointed judge, she's been in trials, and she has not talked to the defendant. She said if they can get reset, just so she can have time to talk to them about the vehicle.
Do you have her contact
I
information?
do not, Judge. She has not reached out to me.
All right, so if you'll make sure defense counsel has her contact number, because this can't proceed without his having spoken to an immigration attorney, unless you're taking all that role.
No, Judge, I only do status changes.
All right, so who is the prosecutor on this case?
I was talking to Brittany Mitchell, Judge. It's a 701 case. But this is gonna be plea or dismissal. Excuse me, it's gonna be dismissal of trial.
Do you have all the discovery?
To the best of my knowledge, Judge, I did file pretrial motions.
Well, last time we were here, there were outstanding discovery on some sort of voicemails.
The jail calls, Judge, and as far as I know, they still have yet to pull those.
All right, so are we ready for trial, really?
Well, my client knows what they are. They're exculpatory. He's informed me what they are.
All right, everyone, lower your voices. All right, so he's telling me that they don't have the jail calls, but his client knows what the jail calls are. So when is he getting his discovery for jail calls? Because we were last here in August for jail calls. And it's about discovery on voicemail, and he's saying the voicemail is the jail calls.
Okay, Your Honor, that's something we can get. I don't know what what happened the last time, or I didn't handle it, but it's something that we can easily get by the end of the day.
All right, other than the jail calls, is there anything else for discovery? All right. All right, so state is going to provide your jail calls today. The other question, state, have you tendered an offer?
We have not given it off yet.
All right, so an offer needs to be tendered. And that's going to be tendered today. And Ms. Ferguson, on this case, I need a reset for next week as a plea deadline date. All right, we're going to come back on September 28th. On September 28th, you need to let the court know whether or not you're accepting the offer that the state has tendered. And also by that time, you need to have talked to your immigration attorney. Is there anything else?
No, you're.
All right, thank you. All right, and if I could have, Norma, if you can have Mr. Cox and Lorraine Efron out here, please.
We have a change of announcement, Judge.
Which case?
Andy Maldonado.
Yes.
We've reached an agreement and we're ready to sign, but I guess you're starting at. 10.
Oh, we're starting at 10, but we'll get that done today.
Okay, do you want us to come at 1 or?
Come back at 11:30.
Okay.
Okay.
And is he in custody?
He is, Judge, it's right here.
All right, so Mr. Maldonado is going to be a plea. So deputies, if you'll hold on to him.
Okay, thanks, Judge.
Who's here on Abel Martinez?
Oh.
All right, we'll come with that. And Jason, I know you're doing 3 or 4 things, but do you know where Mr. Cox and Lorraine Efron are? Would you tell them to come in with their client? And Deputy Laura, if you want to put all of them on hold.
Okay, all right.
Judge, do you want me to see if the jury's here first?
Oh, Deputy Laura is going to check on them. Even so, we're still going to move them out of the box. All right, Mr. Cox, where's your client?
Sorry.
Where's your client?
Excuse me, Your Honor, Canton Longacre, do you want me to stay put?
All right, who's here on Carlos Madrigal Hernandez? All right, have we obtained the birth certificate?
Judge, that's what I wanted to address. They have made extraordinary efforts to get that, and they haven't. I have a receipt from May 26th where they first tried. There's another receipt from August of this year when they've tried. They contacted the online sources that the court had found for us. And they won't be able to do it because of whatever's happening over the Health and Human Services. They did get their certified letter back, and they're just being told, you gotta wait, you gotta wait, you gotta wait.
All right, did anybody call the state representative for
I-
Texas or the US senator?
My mom's just been trying a lot.
All right, somebody called Ted Cruz and asked him
Can I
if
call
we
him?
can get a birth. Yeah, I'm dead serious. Somebody called one of the state representatives, and when I say state representatives, I don't mean our local or our Texas state representative. Somebody called the representative in the US House, or either call the state senators, the US senator's office, and tell them that you're trying to get your birth certificate. I guarantee you that they will put a quick rush on it. So what we're going to do We're coming back at 11:30. Somebody step out in the hallway, call the US representative for Bear County and call the US senator. And I guarantee you, when you get in touch with the person who works in the office, the first thing they're going to do, counsel, is they're going to see if you're a voter or not. If you're a voter, you know what's going to end up happening? They are going to get that birth certificate.
We'll give it a shot.
I had a similar situation with my mom with regards to her passport, and everyone said it's going to take 8 weeks or 10 weeks. So I ordered it well in advance of that 10-week time period, and it wouldn't come. And I was taking her to Paris for her birthday. And you know what I did? I called her representative from Louisiana, and they were like, oh, we're on it. And guess what? That passport was in the mailbox within 2 days.
Nice.
So I know if you call one of the representatives, we'll get the birth certificate. That's your last hope.
We'll do that.
So if you guys will step out in the hallway, call Senator Ted Cruz or whoever else is in the at the Senate level and at the US representative, you'll get your birth certificate.
We'll give it a shot. Thank you.
All right, you're welcome. Nevis Carrillo. Yes.
Trial in federal court October 30th.
All right. Can I see the file on Mendez, please? And I'm sorry, Ms. Ephraim, what date did you say?
October 30th.
All right. Mhm.
Your Honor, we're waiting for treatment by parties and some-
All right. All right, on Joaquin Mendez, Mr. Longacre, Ms.
Yes.
Ferguson, if you could set this in November, his federal trial is October, at the end of October. All right, we'll come back on November 13th.
Thank you, Your Honor. May I be excused? Did you say November the 13th, correct? Yeah.
All right, and then where is your client?
In custody,
All right, just give us a moment.
state hospital.
We're gonna bring them back. We're gonna get ready to bring the jury in a little bit. John Carlo Armstrong. Yes. All right, and you're on the other side, counsel.
I apologize.
All right, what is happening with this case?
Judge, this thing is set for Thursday for our first hearing. I'm just reviewing the first amended MTR this morning. I'm also speaking with probation. Mr. Armstrong hired me about a week or two ago. At this point in time last week, he established contact with his probation officer. There was some confusion between pretrial and probation. Probation came over to the residence.
Oh, it's family violence.
No, it's actually going to be CTD, Judge. So they're going to be handling it because of my status. So,
Oh,
or lack thereof.
Okay.
And so with regards to this case, the probation officer went over to the house, but they said he needed to find a new place. The residence of that house is his mother, who's present today, and his biological siblings who are there. He had been allowed prior to sentencing to be able to live there. Pretrial told him he needed to stay there with his GPS. Probation said he couldn't. We
all
are
right, let me ask you this. Have you conferred with the state on this?
We have not, Judge, because it's set Thursday. I just wanted to be able to go back home.
Well, I mean, you'll need to confer with them over this.
We can confer, Judge.
All right, so do you all confer?
Thank you, Judge.
Yes.
Thank you.
Mr. Cox, your client is here. All right. Yes. All right, court is going to call 2022 CR 3745, State of Texas versus Joseph Dale Harris. Can our parties announce for the record for the state,
Jason Garahan, Daniel Escobar.
for the defense?
Cornelius Cox.
Lorraine Efron.
And are you Mr. Harris? All right, you may be seated. All right, yesterday, there was a question by the defense whether or not the complainant had ever been committed to a state hospital. Is that correct, defense?
That's correct, yes.
All right. And neither party objected to the court trying to discover this information because the defense had sought to discover the information but was unable to. After research by the court, which no party had any objection to the court trying to research the matter, the court received information that the defendant had not been committed in the state hospital. Is that correct, defense?
I think you said defendant, Judge, but I think.
I'm sorry, the complainant had not been committed to the state hospital. Is that correct, defense?
Yes. We agree that that information was made available to us in the court.
And that was the information that was made available to the court?
That's correct.
All right, and defense, do you have any information contrary to that?
Not contrary to that, our position was always that there was evidence suggesting that the complainant had been hospitalized at the state hospital. In terms of the nature and exactly how that came about, we did not have the opportunity to develop that issue.
All right, and the court will note for the record again that according to the court's docketing sheet, that this case has been here with regards to discovery since July 11, 2022. Court will note that the medical records issue were on the court's docket since December 19, 2022.
And if I may respond to that, those medical records that the court is referring to is the hospital records that were conceived when the complainant was when there was attempt to try to resuscitate him or try to save those. The court is talking about records. In terms of any type of mental health records, that information was never provided to us by the state.
All right, and defense, with regards to that information, it's the court's understanding that on body camera and in the prosecution guide, it stated that allegedly the complainant may or may not have been acting erratically. Is that correct?
That's correct.
And when did the defense have the prosecution guide?
Early in the, at least by the time of this case was actually indicted.
All right, and so that would have been in 2022 at least?
Yes, Your Honor.
All right, and when did the defense subpoena attempt to subpoena the mental health records?
I believe that was the mid-August of this year. That's when we attempted to subpoena those records. And the basis of that was not because of anything that the state provided. Their position was always, we don't know anything about mental health records. And my position is that wasn't true. Well, I won't say it wasn't true, but it was not exactly the circumstance.
The court will note for the record that this case has been on the court's docket since July 11, 2022. The court will note for the record that the defense was aware of, or should have been aware of, any type of mental health issues since July 11, 2022. The court will note for the record that the defense did have medical records, mental health medical records subpoenaed in regards to the complainant, and the defense received some of those records. Both the defense and the state asked and had no objection to the court attempting or seeing if the court could discover whether or not the complainant was actually committed to the state hospital, which it was the court's understanding, in which the defense stated that the defense wanted to know whether or not the complainant had ever been committed to the state hospital. And based upon the information that the court has received, which both the defense and the state were made aware of, there has been no civil commitment of the complainant to the state hospital. All right, is there anything else?
And just briefly, Judge, in our position, the defense position is that those records, that mental health issue, our position is that that is consistent with the Brady material. And our position is that for the state to either ignore those issues or not to specifically provide those issues, or whatever information they may have in that line is a direct violation of Brady.
All right, state.
Judge, just to respond to that last statement by defense. These records have been and are currently still not in possession of the state. And I notified defense counsel Cornelius Cox of that several months ago and mentioned that we did not have these in our possession, nor were they in our possession. So just wanted to put that on the record to make it clear that the state has not been hiding or obtaining records and not turning them over to defense. Everything in the possession of the state has been turned over to defense for this trial and for this case.
And the records you're speaking of are the mental health records of the complainant?
That is correct, Your Honor.
All right. All right, Deputy Laura, can you see if the jurors are here? All right, we will wait for those 3 jurors. All right, we'll go off the record. Eric Diaz. Is he in custody? All right, come forward. Good morning. All right. So he's scheduled for jury trial?
I had subpoenaed records, which I received a little less than a week ago.
All right. All right. So, Mr. Diaz, we'll see you tomorrow for jury trial. Ms. Ferguson will give you a reset form. All right, you're welcome. And counsel, if you're requesting a continuance, you'll need to file a motion. Jesse Inaho. Good morning. How are you doing? Oh, I'm doing great. All right, we're scheduled for jury trial. All right, Mr. Inaho, we'll see you tomorrow for jury trial. Ms. Ferguson, if you'll give them a reset form.
Your Honor, just so the court's aware, I am scheduled for a girls' tomorrow.
Okay. Oh, we'll wait for you. And tell Judge Pulliam I said hello. Thank you. Yeah, I'm missing 3, 2. All right. Can you? All right, who's here on John Carlos Cisneros Armstrong? Oh, just have a seat. We'll wait for your attorney. And then Carlos Madrigal Hernandez.
That's Mr. Hernandez, Judge.
Okay. And then Mr. DeLeon, your person is Nieves Carrillo,
Yes, Your Honor.
and he's in custody.
She is in custody.
All right. Can you bring her out, Deputy Mejia? Thank you.
She's on the docket.
Oh, she's not on the docket?
Yeah, she's not in-
Oh, Deputy Mejia, she's not on the docket. So if you go back there to search, she will not be there. All right, so what are you requesting for this? All right, so what we'll need is we'll need to have them present. And we'll make that happen. So just get with Ms. Ferguson to see if she can put it on the docket this week. Yes. Yes. Oh, I like to hunt for which room you're in. All right, and they're all here. All right, everyone, the jurors are here. And each side would have 30 minutes for argument. How do you all want your time broken down, State?
Your Honor, I just would like a 5-minute warning before it runs out.
All right,
Judge, can you give me a 5-minute warning when 5 minutes have expired?
okay. Defense?
We're gonna do 15, judge, and we're at 2 minutes away.
All right. All right, so we're going to go on the record. In 2022 CR 3745, State of Texas versus Joseph Dale Harris. Again, could I have parties announced? Excuse me, counsel, you need to move. Could I have parties announced?
Jason Garrett, Daniel Escobar, ready?
Defense?
Cornelius Park and Lorraine Efron.
And are you Mr. Harris?
Yes, ma'am.
All right, have both parties had a chance to review the charge of the court or the jury charge, State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
All right, any objections to the jury charge, State?
Your Honor, the only, we'd like to put on the record that we were asking for the paragraph 4 on page 5, which speaks about apparent dangers to be removed. And off the record, I believe you had already ruled on that it is going to stay, that the state's just objected to that.
All right, thank you. Defense, any objections?
No objections.
All right, let's bring the jury in.
All right, for the jury.
And everyone, please make sure your phones are silent. There is nothing worse when people are doing arguments and the phone goes off. If your phone goes off, just leave the courtroom and wait outside. All right, everyone, please be seated. All right, defense. Call your next witness.
During this time, the defense rests.
State.
State moves to close, Your Honor.
Defense, do you close?
We close.
All right, thank you. All right, ladies and gentlemen, you've heard all the evidence that you're going to hear in this case during this phase. What I'm going to do is I'm going to read to you what's called the charge of the court. You do not have to memorize it. A copy, well, not a copy, the original will be given to you to review. All right. Charge of the court. Members of the jury, the defendant, Joseph Dale Harris, stands charged by indictment with the offense of murder alleged to have been committed on or about the 28th day of February 2022 in Bexar County, Texas. The defendant has pleaded not guilty. 1, our law provides that a person commits the offense of murder if he intentionally or knowingly causes the death of an individual, or if he intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. 2, individual means a human being who is alive. A deadly weapon means a firearm or anything that in its use or intended use is capable of causing death or serious bodily injury. A firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance or any device readily convertible to that use. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means a bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. 3, a person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. 4, now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 28th day of February 2022 in Bexar County, Texas, the defendant, Joseph Dale Harris, did intentionally or knowingly cause the death of an individual, namely Isaiah Orozco, by shooting Isaiah Orozco with a deadly weapon, namely a firearm, or the defendant, Joseph Dale Orozco, with intent to cause serious bodily injury to an individual, namely Isaiah Orozco, did commit an act clearly dangerous to human life that caused the death of Isaiah Orozco by shooting Isaiah Orozco with a deadly weapon, namely a firearm, then you will next consider whether Joseph Dale Harris acted in self-defense or in defense of a third person or persons and proceed to paragraph 5. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Joseph Dale Harris, not guilty and do not consider paragraph 5. 5, self-defense. You are instructed that it is a defense to this prosecution if the conduct of the defendant was justified by law. A person is justified in using force against another when and to the degree he reasonably believes the force is immediately necessary to protect himself against the other's use or attempted use of unlawful force. A person is justified in using deadly force against another, 1, if the person would be justified in using force against the other in the first place as set out above, and 2, when and to the degree the person reasonably believes the deadly force is immediately necessary to protect himself against the other's use or attempted use of unlawful deadly force. The use of force against another is not justified in response to verbal provocation alone. Reasonable belief means a belief that will be held by an ordinary and prudent person in the same circumstances as the defendant. Deadly force means force that is intended or known by the person using it to cause, or in the manner of its use or intended use, is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition, including death. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. A person, 1, who has a right to be present at the location where the deadly force is used, and 2, who has not provoked the person against whom the deadly force is used, and 3, who is not engaged in criminal activity at the time the deadly force is used, is not required to retreat before using deadly force. If all 3 of these factors are met, then in determining whether such actor reasonably believed that the use of force was necessary, a finder of fact may not consider whether the actor failed to retreat. A person has a right to defend from apparent danger to the same extent as he would had the danger been real, provided he acted upon a reasonable apprehension of danger as it appeared to him from the standpoint at the time. You are instructed that the defendant's belief that the deadly force was immediately necessary is presumed to be reasonable if the defendant, 1, knew or had reason to believe that the person against whom deadly force was used was committing or attempting to commit murder, and 2, the defendant did not provoke the person against whom the force was used, and 3, the defendant was not otherwise engaged in criminal activity other than a Class C misdemeanor that is a violation of a law or ordinance regulating traffic at the time the force was used. The presumption of reasonable belief applies unless the state proves beyond a reasonable doubt that the facts giving rise to the presumption do not exist. If the state fails to prove beyond a reasonable doubt that the facts giving rise to the presumption do not exist, the jury must find that the presumed facts exist. Excuse me, have a seat. If the jury has a reasonable doubt as to whether the facts giving rise to the presumption do not exist, the presumption applies and the jury must consider the presumed fact to exist. Even if the jury finds that the state has proven beyond a reasonable doubt that the facts giving rise to the presumption do not exist, the state must prove beyond a reasonable doubt each of the elements of the offense charged in the indictment. Defense of a third person. A person is justified in using deadly force against another to protect a third person or persons if one, under the circumstances as he reasonably believes them to be, the actor would be justified under the law of self-defense as instructed above and using deadly force to protect himself against the unlawful deadly force he reasonably believes to be threatening the third person or persons he seeks to protect. And two, the actor reasonably believes that his intervention is immediately necessary to protect the third person or persons. The defendant is not required to prove self-defense, and the defendant is not required to prove defense of a third person or persons. The state must prove beyond a reasonable doubt that the defendant did not act in self-defense and that the defendant did not act in defense of a third person or persons. Now, keeping in mind these instructions regarding self-defense or persons, even if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Joseph Dale Harris, committed the charged offense of murder, you must decide whether the state has proven beyond a reasonable doubt that the defendant did not act in self-defense and that the defendant did not act in defense of a third person or persons. Self-defense application. Therefore, if you find from the evidence beyond a reasonable doubt that the defendant, Joseph Dale Harris, committed the offense of murder as charged in the indictment and as instructed in paragraph 4, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, 1, Joseph Dale Harris reasonably believed or is presumed to have reasonably believed, as viewed from his standpoint, that Isaiah Orozco was using or attempting to use unlawful deadly force against Joseph Dale Harris, and 2, Joseph Dale Harris reasonably believed, presumed to have reasonably believed, as viewed from his standpoint, that his use were immediately necessary to protect himself against Isaiah Orozco's use or attempted use of unlawful deadly force. And 3, Joseph Dale Harris's use of deadly force was not in response to verbal provocation alone, then you will find in favor of the defendant on his claim of self-defense and acquit the defendant, Joseph Dale Harris, and say by your verdict, not guilty. However, if you find from the evidence beyond a reasonable doubt that the defendant, Joseph Dale Harris, committed the offense of murder as charged in the indictment and as instructed in paragraph 4, and you further find from the evidence beyond a reasonable doubt that 1, Joseph Dale Harris did not reasonably believe and is not presumed to have reasonably believed, as viewed from his standpoint, that Isaiah Orozco was using or attempting to use unlawful deadly force against Joseph Dale Harris, or 2, Joseph Dale Harris did not reasonably believe and is not presumed to have reasonably believed, as viewed from his standpoint, that the use of deadly force and degree of deadly force used was immediately necessary to protect himself against Isaiah Orozco's use or attempted use of unlawful deadly force, or 3, Joseph Dale Harris's use of deadly force was in response to verbal provocation alone, then you will find against the defendant on his plea of self-defense. But next, consider whether the defendant acted in defense of a third person or persons as instructed below. Defense of a third party application. Keeping in mind the instructions above, if you find from the evidence beyond a reasonable doubt that the defendant, Joseph Dale Harris, committed the offense of murder as charged in the indictment and instructed in paragraph 4, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, one, Joseph Dale Harris reasonably believed or is presumed to have reasonably believed, as viewed from his standpoint, that Isaiah Orozco was using or attempting to use unlawful deadly force against a third person or persons. And two, Joseph Dale Harris reasonably believed or is presumed to have reasonably believed, as viewed from his standpoint, that his use of deadly force and the degree of deadly force used were immediately necessary to protect the third person or persons against Isaiah Orozco's use or attempted use of unlawfully deadly force. And three, Joseph Dale Harris reasonably believed or is presumed to have reasonably believed, as viewed from his standpoint, that his intervention was immediately necessary to protect the third person or persons. And four, Joseph Dale Harris's use of deadly force was not in response to verbal provocation alone, then you will find that the defendant, Joseph Dale Harris, acted in defense of a third person or persons and acquit the defendant and say by your verdict not guilty. However, if you find from the evidence beyond a reasonable doubt that the defendant, Joseph Dale Harris, committed the offense of murder as charged in the indictment and instructed in paragraph 4, and you further find from the evidence beyond a reasonable doubt that one, Joseph Dale Harris did not reasonably believe and is not presumed to have reasonably believed, as viewed from his standpoint, that Isaiah Orozco was using or attempting to use unlawful deadly force against a third person or persons. Or two, Joseph Dale Harris did not reasonably believe and is not presumed to have reasonably believed, as viewed from his standpoint, that his use of deadly force and the degree of deadly force used were immediately necessary to protect a third person or persons against Isaiah Orozco's use or attempted use of unlawful deadly force. Or three, Joseph Dale Harris did not reasonably believe and is not presumed to have reasonably believed, as viewed from his standpoint, that his intervention was immediately necessary to protect the third person or persons. Or four, Joseph Dale Harris' use of deadly force was in response to provocation. Four, Joseph Dale Harris's use of deadly force was in response to verbal provocation alone. Then you will find against the defendant, Joseph Dale Harris, on his plea of defense of a third person or persons, and find him guilty of the offense of murder as charged in the indictment. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website, to include, but not limited to, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, or Twitter, to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court, which is herein given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of the fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, or after considering all the evidence before you in these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any questions you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the bailiff. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas, and suitable forms are attached. State, are you prepared to proceed?
Yes, Your Honor.
All right, you may begin.
I quickly wanted to cover with you a few things that are in that jury charge. First thing I wanted to say is that you are going to get the jury charge during deliberations. You don't need to memorize anything that I have to say. The first, as Jason mentioned in voir dire, is that there are 2 paragraphs to a murder charge. Now, it doesn't need to be unanimous agreement as to which paragraph applies. If 6 of you say paragraph A and 6 of you say paragraph B, that's enough. Let's go over it. So paragraph A. We've proven the date, February 28th, 2022. Many witnesses came forward and said that was the day that this happened. Bexar County, Texas. This happened a few blocks away from the courthouse. This happened in Bexar County. The defendant, Joseph Harris. Multiple people said that the same person that the police ended up apprehending was the same person who shot. And Joseph Harris admitted to the detective that he was the one who fired his weapon. That's not in dispute. Intentionally or knowingly caused the death of Isaiah Orozco by shooting him with a deadly weapon, namely a firearm. None of that is in doubt. Isaiah died as a result of his injuries. The defendant shot at him 16 times. He intended to kill him. Now, many of the elements in paragraph B are similar or the same. Again, the date, Bexar County, the defendant. The main difference is intent to cause serious bodily injury by committing an act clearly dangerous to human life that resulted in the death of Isaiah Orozco. Again, he shot at Isaiah 16 times. He intended to cause serious bodily injury, and it caused Isaiah's death. Either way, the state has proven each of these elements beyond a reasonable doubt. Now, as it's said in the jury charge, you will not be getting any police reports that have been mentioned in this trial. Plenty of them have been brought up. You cannot let bias or sympathy play a role in your determination. You must look at the facts and what's been presented. The state has met its burden. We've shown overwhelming evidence here. We ask that you find the defendant guilty of murder. The state reserves all remaining time.
All right, defense, are you prepared?
Yes, Your Honor. I was in fear. I was in fear for my life. That's what you heard Mr. Harris say. He was in fear for his life. The state has to prove each and every element beyond a reasonable doubt. They have to prove he did not act in self-defense. They have to prove he did not act in defense of a third person. They have to prove he did not act reasonably. All of those things are presumptions in favor of the defendant. The presumption of innocence alone is enough to say not guilty. But here we have, I was in fear for my life. And we have, stop texting me, stay off my block, stay off my block. Well, he's not saying these words and pulling out his cell phone, stop texting me. No, he's saying these words and flashing his gun, pulling his gun out, right? You are supposed to view this in the eyes of Mr. Harris. Did a reasonable person standing from the viewpoint of Mr. Harris? Now, in this case, you've heard a lot of different viewpoints here, right? We hear from witnesses at this building, that building, here, and the bus, and there's a whole lot of vantage points that you heard from. But the one that matters is Mr. Harris's. And he told you what he observed from where he was standing. He sees a gun. He hears crazy talk. What did you hear the witnesses say today or over this last week? His words were confusing. They did not make sense. They were loud. They were confrontational. They were threatening, erratic, mental, belligerent. You heard witnesses say those things: mental, belligerent, loud, erratic, and he had a gun. And the cell phone, his cell phone's not in evidence. His gun is. I was in fear. I was in fear for my life. Witness says, you saved lives today. You saved lives today. You saved lives today. That's uncontroverted. That was said to him. Mr. Harris says, I was in fear. I was in fear for my life. And what does he do? He stands there. He says, call the police, call 911. He did not hide. He did not evade. He did not resist. He stood there. He waited. Asked people to please call the police, call 911, and he waited. And what did he do when the police arrived? He cooperated. He said, I did it. I did it. That's a person who acted in self-defense. That's not a person who has something to hide and is trying to run and hide behind a corner. I mean, this was a busy downtown street and block, right? Lots of buildings around and lots of people around. And that's what you saw from all the pictures and videos. One thing that is over, you see in all of that is all the people that are around, right? And that you confirm are around because that's not, you don't see a 360 view, right? You see trees, you see shadows, you see a whole lot going on, you see city noise, people are hearing and seeing different things from where they stand. But from where Mr. Harris stood, and look, not only several witnesses said he said, stop texting me, stop texting me. No one said he had his phone, stop texting me. No one understood who was texting him. Who was texting him? Was he getting it from a street lamp to his head? We don't know, right? We don't know if he was getting any actual text messages that day, but we know he was receiving them in some way because he was complaining and he said, stay off my block, stop texting me, here's my gun. The law of self-defense is that a person that a person reasonably believes that the force is necessary to protect himself. Reasonable belief is a belief that would be held by an ordinary and prudent person in the same circumstance as defendant. It's not any reasonable person. It is a reasonable person standing in Mr. Harris's shoes. I was with my buddy. I was catching the bus. It was my daughter's birthday. I hear this guy. It's so unusual. I hear him. I see him walking around the block. I don't know what's going on with him. And then he starts flashing the weapon. He doesn't have a duty to retreat. He does not have a duty to retreat. He has a gun. He's in fear for his life, and he has the ability to do something about it. He saved his life. He saved others' lives that day. And the presumption of reasonableness goes to Mr. Harris. The presumption of reasonableness goes to him. The state must prove to you he did not act reasonably. And the state cannot prove that because he did act reasonably that day. He has the right to respond to real danger and apparent danger. A gun is a loaded gun. Does anyone dispute that? You see a gun, what else is it but loaded, right? You might be able to clear it and put a zip tie on it later and hey, it's cleared, it's all safe. But on the street, it's being displayed with some crazy talk. A gun is a loaded gun. That's real danger, it's apparent danger, and it's no other. The state can't prove otherwise. The state must prove that Mr. Harris did not act in self-defense. They have not proven that he did not act in self-defense because he did. He has a right to defend himself from apparent danger, and he did. Mr. Harris gets a presumption of innocence here. Mr. Harris responded in fear. There was not a moment in time where you have time to analyze whatever. It is happening now, and you have to act. Your life or someone else's. You're going to save your life and the lives of others. You must act, right? And that's what he did. He was in fear. He was in fear for my life. That's what he told you. I was in fear for my life. I was trying to make it to my daughter's birthday party. I didn't want to die that day. I did not want to die that day. And this guy was talking crazy talk and flashing a gun. I didn't know what was up. He was erratic, bizarre. He had a gun. It was a busy busy street with lots of people around, and I did the only thing I could do, save myself and save the lives of those around me.
Defense?
May it please court. Attorneys for the state. Members of the jury. This part of the trial is called or known as summation of closing arguments. And basically, this is the time where the warriors have an opportunity to speak to you, to highlight what we feel that the evidence in this case shows. It's important for you to know that what the lawyers say is not the evidence. It was a week ago. You all started a journey with us, because in this room, we selected this jury with the responsibility of determining whether the state had proven its case beyond a reasonable doubt. You promised by your oath that you would hold the state to that burden. And if they fail, notwithstanding perhaps their good intention, if they fail to meet that burden by your verdict, you must acquit the accused. Now, we only have one opportunity to speak. And the state has a second opportunity. So when I'm seated, they can come up and they can say things and I can't rebut it. So I need to kind of address what they said already and anticipate what they may say when I'm seated and I can't say anything. Proof beyond a reasonable doubt. But first, we thank you for your patience. We thank you for your attentiveness. And we thank you for meeting the challenge of analyzing this case, coming forth with a verdict. Sometimes in trials, like this, what the state is going to do probably is they'll probably show you the video that you see. They may show you the photographs and tell you that there's only one verdict that you must render in this case, because when they show you the photographs, they may show you the weapon and tell you that this case kind of cries out, and you need to go back into the jury. And the verdict, guilty. Now, I feel that your job is more profound than that. They may come to the state and sometimes they'll pound the desk. They may point at the accused and paint him as a person that's not reasonable, that acted, beyond reasonableness, and you should convict. But as you think about the evidence in this case, as you go through these sections, or sometimes you may decide with witnesses to take each one's testimony. The question that probably should pop out to you is why? Why? State's correct. February 28th, 2022 was the day of this event. Why? For my client was a typical day. The evidence in this case shows that that morning, he had no intent to shoot anybody, to have to defend himself. The only thing that he was considering was catching a via bus and preparing for his 2-year-old daughter's birthday. Question, why? Why does he find himself here today? Typical man. Daughter's birth. Preparation. Now, what you know is that he meets an acquaintance, and they're both going to catch the bus, and they having small talk, and at that nothing at that point in his life, in his experience, that's going to put him in this chair. And what happens? He sees a person who we know at this point is the complaint. He sees this person, and at this point, Mr. Harris is minding his own business, his own affairs. All of a sudden, is just yelling by this person. For some reason, there's a fixation with my client and his friend. Why? Why the fixation on those? Yelling about why are you on my blog post, or this is my blog. What? He's seated on a bus bench, minding his own affairs. And all of a sudden, why are you on my blog? It happened to anybody. Why are you on my blog? He's waiting to catch the bus. Then why are you texting? Where does that come from? So in terms of what's, and you heard Mr. Harris testify, in terms of what's going on, you're trying to, in real time, I would imagine, trying to focus, trying to get an understanding of what's going on. Then there's an escalation. Now, the state is probably going to say, well, my client, he escalated the situation. No, where the escalation comes from is that the complainant at this point reveals that he has a firearm, not a cell phone, not a fan to cool yourself. He has a firearm. So you compound what he's saying, the erratic behavior, and now the person exhibits a firearm. Co-counsel was right. So what do? Is not a situation, you see, even in this courtroom, there was firearms that were displayed, and it was always concerned, even in a controlled environment, to make absolutely sure that they weren't active or low. You're on the street, minding your own business. Somebody approaches and they got a firearm. Why? I submit to you that when the state comes before you and they want to show you the pictures, let them explain the justification for the complainant to exhibit and be aggressive with the firearm. Why? Why? That's why we're here. And what's the testimony after that? Mr. Harris, he approaches with his hands up. That testimony is not contrary. He has his hands up. Wanting to what? De-escalate the situation. Has his hands up. And the law says, if you look in the charge, that my client, in terms of self-defense, he's in a place lawfully. There's nothing wrong with being in a location against us. She's not doing anything legally. What he does, hands up, and he kind of approaches people. And the reason for that is that he wants to de-escalate the situation. Stay, and like I said, they may show you the video over again and over again. They may stop. They'll probably try to suggest to you that this person that's speaking erratically, and because that person appears to kind of like turn a little bit, that the danger is over. They may even suggest that because the crime scene technician indicated that there wasn't actually a bullet in the chamber of the complainant's weapon, that he was harmless. If you remember when I asked the witness that how long would it take to rack the weapon? And we started at what, 5 minutes, 3 minutes, 4 minutes. We got down to say maybe a second. And we didn't talk about distance, but even from where he was, even if he backed away, the complainant, he still fired a shot. And he had enough bullets in his weapon to kill or hurt a lot of folks at that bus stop. Why? Client only wanted to spend time with his 2-year-old daughter. He wasn't able to. Why? Because he's a citizen, a resident of San Antonio, Bexar County. And he only wanted to sit on a bus bench and wait for a bus to get to his family. Lead detective. And what did the lead detective say? Well, it's my job to make the case, get all the information and decide to make the case or not make it. And there were discussions he talked about. We never heard whether there was any evidence whatsoever that, and the officer testified that they had my client's phone that he or anybody else was texting the complaint. What was the fixation? Why? I asked the detective, lead detective, I said, well, there were, what, 50, 60 police officers involved in this case. Did you suggest to anybody or yourself to go out and see if you can get other video from other buses in the area
Minutes.
that leads up to what happened? The officer says no. The detective said no. Why? Because they were fixated just on the shooting. Not about what happened prior to it. The burden that the state has, and we talked about it during jury selection, proof beyond a reasonable doubt, and that burden does not change. I submit to you that this is a case of self-defense, a classic case of self-defense. And you don't have to wait until somebody acting erratic shoots a lot of people before you act. He acted that day. His actions were, from his vantage point, reasonable. And I submit to you that the only just verdict that goes along with the evidence in this case, and no matter how many times they may come and try to point and hit the table, the only just verdict in this case is a verdict of not guilty. Thank you.
Right, State, are you prepared to proceed?
Sure. Defense counsel. Court. All right, ladies and gentlemen, I'll be the last person to talk to you today, and we're gonna start deliberating in the back. And not opposed to beating on tables or desks or anything, but I think the facts sort of speak for themselves. You've seen the video numerous times. And yes, I'm gonna show the video again in a little bit, because we don't get videos like that very often. Defense counsel said this is classic self-defense. Classic self-defense. Read that jury charge. I ask each of you, come back in here with a not guilty if you believe this is self-defense. I'll tell you that Officer Robles arrived at the scene. This is from his body worn camp. That's how he saw Mr. Isaiah Orozco laying there on his side, headphones near his head, bleeding. Defendant down the road on the sidewalk saying he's the one that shot. Because as Mr. Escobar, my co-counsel, stated, the elements are not in question here at all. Defendant admitted to shooting him. It happened here in Bexar County on February 28, 2022. So I'm not going to go over that. Because as defense counsel went over the self-defense claim, that's what we're going to focus on. Because that's what they're claiming, that this was classic self-defense. Now, as we go through the witnesses, I'll tell you this. Mr. McDowell, Michael McDowell. Do you believe him? As he stated.
Excuse me, just 1 minute. I'm gonna pause you. Deputy, please let her remain outside. All right, you may resume.
Thank you. Ladies and gentlemen, Mr. McDowell, I don't think he has a bone in his body that would be considered a liar. He's very credible.
He stated that the individual Isaiah Orozco, the complainant in the case, was not angry. He was just telling him, stay off my block, stop texting me. You go on to other individuals like William Fowler. You could tell from the way he testified that that was a very emotional day for him to witness somebody being hunted down, chased, shot right in front of him numerous times. And the last shot going to the head and seeing what he said looked like confetti coming out of his head, parts of his body flying off his head. That's that last shot. You heard from Gonzalo Salinas that stated that he had a vantage point at 3 stories up. As he looked outside after he heard shots, he saw this man over here walk up to Isaiah Orozco and shoot again. There's that pause in the action. The pause in the action. The kill shot. A shot to the head is what killed this man, no doubt. The fact is, that was the last shot. Numerous testimony from numerous witnesses came in saying that. That man over there chose to do that to that man. Self-defense, classic self-defense. You had Julio Zamora state he heard the shots, he heard that pause, and then the last shot. As he looked out the window, he saw this man walking back to the bus stop by that wall and giving a fist bump. Classic self-defense. You heard from the defendant. You saw his statement. Compare that statement to what he testified to on the stand. It's fuzzy when he was giving his statement, supposedly. He couldn't remember exactly. It was hours after, but he was fuzzy. He couldn't remember. Well, you know, another thing about that is he never saw that video until after. He didn't see that video that day. So he was able to make up his story, because if you go back to that statement, he states there's no videos. There's no way there's a video. It's too quick. By the grace of God, a Via bus pulled up. He didn't know that Via bus had those cameras on there. That's why his statement, when he gave it to the police, was much different than when he got up on the stand and testified to you the other day. He had to correct his story. He had to lie. He had to be fuzzy memory then. You'll look in that video and you'll see Isaiah Orozco doesn't keep on turning around. That's not in the video. You don't see him pulling up his shirt over and over as the defendant gave his statement. You will not see him turn around. You will not see him pull up his shirt. You won't see him display the gun more than that one time. And he puts it down. Now let's talk about self-defense here. Again, justification for Isaiah Orozco to display his gun. I'm going to tell you this. We're never going to know the motive between these two individuals. We're never going to know the history of that, ever. Defense counsel kept on asking why. Well, I told you in voir dire, motive is not an element. So that's off to the side. The why doesn't matter. That's motive. So when we discuss about justifications, defenses to this type of crime, let's talk about Isaiah Orozco. He's having some type of argument, some type of discussion, probably heated, with this individual, maybe not this individual, maybe Jason Lexon that you've heard testify, which obviously he wasn't very credible. No matter what, there was something going on between them. But Isaiah Orozco stood there discussing with him. He didn't pull out a gun when he was discussing anything with him. But when 6 foot flat, 255-pound man gets up and starts advancing towards him at 5'3" and maybe soaking wet 130 pounds, Isaiah backs up, pulls the gun. What does the defendant do? He stops. He sees the gun. That's reasonable. You see a gun, you're going to stop. He's going to stop advancing towards him. What does Isaiah Orozco do then? After he stops advancing, he puts the gun back in his pocket. He stands there. He gives this signal. You can take for that what you believe that means. And then he points the opposite direction. And he decides to turn around. So self-defense. Isaiah Roscoe could use self-defense on himself, for himself, just as this man can. Same, you can, I can. Was Isaiah Roscoe reasonable then? He believed he was being advanced upon by a superior individual physically. That he believed possibly that his life was in danger. Or serious bodily injury.
Facts in the law.
All right, ladies and gentlemen, you remember the witness's testimony as you heard it. And with regards to the law will be given to you in the charge of the court. Yes.
So you determine whether that's reasonable. But no matter what, he puts that gun back in his pocket and decides to turn the other cheek and walk away. And one person decided to pull out their weapon and use it that day. And it's that man sitting over there claiming self-defense, classic self-defense. So when we talk about self-defense, as in voir dire, you saw these charts that I gave you earlier or last week. Remember, I highlighted reasonably believes that the force is immediately necessary. You tell me that the force is immediately necessary when I have my back towards you and I'm walking away. Walking away. Same thing, deadly force. To use deadly force, where are those highlighted words again? Reasonably believes, immediately necessary. Again, my back is towards you. I don't have a weapon in my hand and I'm walking away. Reasonable belief, it's in the definitions in there, but an ordinary prudent man in the same circumstances as they happen. Reasonably believes that it's immediately necessary to shoot a man 16 times, or rather, shoot at him 16 times. Remember this from the voir dire that I gave you, or in front of you. It's not a future threat. Not that, hey, he's gonna come back and shoot you. Must be immediately necessary. Can't be words alone, as a defendant testified to, that when he was walking off, he was saying words. I couldn't hear what he was saying, but it was saying stuff. I implore you that Isaiah Roscoe was abandoning this situation. He turned around and left. He was done. This was not a reasonable reaction by the defendant. It was not a de-escalation, it was an escalation. So self-defense, especially deadly force, should be a last resort. Use your common sense here. This is common sense, and it's not a classic case of self-defense. Isaiah turns his back and walks away from the defendant. You'll see where they're standing. This is from the video. You see where Isaiah is turning around, and you see the defendant standing off by his buddy, Jason. You'll see Isaiah walking away. He takes 7 to 8 steps. 7 to 8 steps. That's 1, 2, 3, 4, 5, 6, 7, almost 8 before this man opens fire on his back. 7 to 8 steps as he's walking away. Classic self-defense, as defense counsel presented. Defendant chasing down Isaiah. This is where he begins to run. He begins to run after Isaiah. Isaiah's back is still to him. Still. He continues to chase Isaiah until he falls. And maybe he should stop there, but he decides not to. He advances one more time. Those pause in the shots. That 15th shot to the 16th shot, there's a pause. You can hear it on the video. He walks up to him and shoots him in the head. Although, defendant testified that that was an accident. He didn't mean the last shot. Just happens to hit him square in the head. right in the middle. You saw the pictures of Isaiah's head. Pretty good accidental shot. It's not an accident. He chose to take this man's life. He chose to be the individual that decided whether that man lived or died, because for any other reason other than the defendant, or I'm sorry, Isaiah displayed a weapon towards him, put it back in his pocket and turned his back. So at this time, we go ahead. I'll tell you this, defense of himself, absolutely not. Classic self-defense, absolutely not. Defense of a third person, I don't even know why I need to address it, but I will since it's in the charge. Absolutely not. Mr. Isaiah Orozco didn't display that gun to anybody else other than the defendant, because the defendant was advancing upon him and he was a superior physical individual coming towards him. Mr. Isaiah Orozco did the right thing. He put the gun back in his pocket and turned the other cheek and walked off. And that led to his death because he took the high road. Now, maybe having a weapon, you've heard he had this weapon from an artist gun club that he obtained it legally. And as he's walking away, this individual with his firearm takes the low road. Says, not today. I'm going to take you out today. And he does that exact thing. What I can tell you is don't make this okay. Don't make this okay. Shooting somebody 16 times in the back is not okay. Use your common sense. And I implore you that this is a guilty of murder. Plain and simple. Thank you.
All right, ladies and gentlemen, you've heard all the evidence that you've heard in this case. Each time I keep telling you, I'll let you know when it's to deliberate. So you're going to be taken to the back where you can select your foreperson and then you can begin your deliberations. If I can have Mr. Gallegos, if you would remain in the box, please. And everyone else, Deputy Laura will take you to the jury room. Remember, please rise. Right, if I could see defense and state, please. Oh, everyone, please be seated. So what happened was we're not allowed to be the same the jurors while they deliberate. My same instruction for a 5 year, do not start deliberating in the first with anybody else. Do not watch anything. That you need to know about this case is to come from the inside of the courtroom. And I give you these instructions and not release you because something still could possibly happen and they may need you. And in which case, if they do, they'll start deliberating from round 0. And then that's the way it will be done. But I am having the lunch orders, so they'll get your lunch. And if you go to the back, Deputy Laura knows the drill. And she'll put you in a different location or you need to walk around. If you're going to walk around, make sure your bag is still displayed. And then you can take your, if you need your personal items from that, just let Deputy Laura know. All right, thank you. Like, if you guys are just leaving your numbers, well, I think everybody has it. Yes. Oh, is this for, Daniel? Is this? All right.
I'm sorry about that.
Oh. And state defense, if you can make sure that the court reporter has the correct evidence. Oh, you got it? Okay.
I didn't touch it.
Is it a case on the docket today? All right, you'll need to have the file pull. Have you conferred?
No.
No. Well, I require that people confer. Oh, you need to speak to the state though. That's what we're here for. All right, and Deputy, I sent Victor back there. Okay.
I mean, I don't mean that in a. But I do agree.
I do have the file. All right.
Is it on today?
Yeah.
Yes. Yes. State defense, if y'all could approach. Yes. Mr. Cox. Yes.
Judge, may I approach?
Yes.
I have a jury laptop. So they can watch the TV.
Oh, we do have we have something in the back for that.
Oh, they don't need this?
No,
Oh, okay.
unless there's a special program that needs to be downloaded, but they'll let us know if they need to view something.
Okay, I'm gonna hold on to it. I'm
Yes.
gonna take it back to IT.
All right, thank you.
No, I just, this is the jury laptop.
Yes, yes,
I didn't think there was something with
yes, yes.
Yes.
And do you know the rest of the exhibits, or are those the only ones?
I just got the live, the live.
All right, everyone, please whisper. You're still in a courtroom.
And there's no other live route. I've already checked the post.
All right, thank you.
But just, I wanted to make sure, even though we were limited, I'm not going back.
Yeah. All right, who is here on Carlos Madrigal Hernandez?
Morning, Greg. I'm calling out here. The other one.
So where are we on his birth certificate?
Should I reach out to the federal system? They said no, state system. I talked to, I called Trey Martinez Fisher's office, left a message. I talked to Cynthia at Senator Menendez's office, and she will be reaching out. I gave her all the contact information for his mother. She said she could.
All right, so did you call the US Senator and the US State Representative?
I called Joaquin Castro, which would be the senator's office. I spoke to a gentleman there. He told me that because it's a state agency and not a federal agency, that I would need to contact the state.
Okay.
And he actually gave me Trey's contact information, but we had to leave a message. I did speak with Cynthia.
Right. All right, so we're coming back next week for an update.
That's fine.
Ms. Ferguson, I need a 1-week reset for discovery on the defendant's birth certificate so that the immigration attorney can determine the status on this case.
And just for clarification, as we've been telling the court before, it's a little bit more complicated than that. It's his mother's birth certificate, too. She's a
No.
US citizen, so that he can,
No, I understand.
if he's actually born in Mexico.
All right, we're coming back on September 26th to see what's going on with the birth certificate.
Thank you.
You're welcome. Just sign a reset form and then you're excused. Just a moment. Who's your client?
Abel Martinez.
All right, have you asked him to pull the file?
Close top of the VA and they don't have file. Abel Martinez.
No, is he on the docket today for his indicted case?
No, he doesn't have indicted for it. They're not indicted.
Okay, then why are we here?
Because the defendant came in on the pre-indicted case, and you told me to contact the defense counsel.
All right, have a seat. I'll give it to you when it comes up. I have other cases before you.
He should be in the box, and he's arrested. He had a warrant.
All right, I'll take it up once he's out here. You're welcome. Leonardo Rosales. All right, he needs an interpreter. All right, you need to ask them to call down an interpreter. Juan Tehran. All right, we're waiting for your attorney. Juan Tehran, come up. All right, Mr. Tehran, you're coming back tomorrow for jury trial.
Yeah.
Is there anything else?
There may be some issues taken before the trial judge, but it's.
What issue?
Well, like limiting motions and objections to the outcry, submitted questions.
All right,
We're discussing.
if you all will switch sides, please.
Oh, I thought it was.
All right, so everyone, this is the last time I'm going to say that people need to whisper. If people cannot whisper, what's going to end up happening is while I have people before me, no one will be talking. I'm amazed that people cannot whisper when they're in the gallery and when they're in the audience, but then when they come before me, I can barely hear them because people want to come before me and whisper. That will not happen. So if you cannot whisper in the gallery, and I have to repeat this again, no one will be talking while people are before me. Counsel. So what motions?
Just the usual stuff like limiting judge, we've got to make objection to the outcry.
Okay. All right, we'll have the outcry hearing with the trial because I'm assuming the witnesses will be here at that time.
All the kinds of things I'm talking about are housekeeping things that normally you would do before the trial starts, yes.
Okay.
Although the state and I are also talking about some witnesses and some information we've gathered that we want them to be aware of. How that influences everything, we're not sure. We're sorting all that out.
All right, Ms. Ferguson will give you a reset form. We'll see you back here tomorrow at 9 a.m. All right, thank you. Norma, that's Tehran.
Yes.
Juan Carlos Cisneros Armstrong. And we're waiting for the interpreter on Rosales. And then if we could have Abel Martinez come out. Who are the prosecutors on Abel Martinez as a theft of a firearm?
Should be me, Judge.
All right, have you conferred with the defense attorney on a bond? All right, y'all can have the bond issue heard by Judge Nahara.
Signature?
Some other day or today or?
Oh, you'll have to file a motion. Is Mr. Tehran here?
Yes, Your Honor.
No, I'm sorry. Abel Martinez III. Has he been brought out? All right, Mr. Martinez, if you'll come up. Hello, Mr. Martinez. All right, Mr. Martinez, a charge has been brought against you as theft of a firearm. I'm just going to go over your rights with you because I have to give you your warnings. I don't know anything about your case, so I can't tell you what the facts of it or what it's about or not. That's your attorney, so your attorney could probably speak to you, okay? All right, you have a right to remain silent. That means that you don't have to speak to anyone if you don't want to speak to them. You have a right to retain an attorney or hire an attorney or have one appointed to you if you can't afford an attorney. Do you have an attorney already? All right, he's right behind you talking to the state and ignoring what's going on at the bench, but that's okay. All right, you have a right to have an attorney appointed to you if you can't afford an attorney. You have a right to have a reasonable time to consult or speak with your attorney. You have a right to have an attorney present with you if you decide to give an interview to any officers or any prosecutors. Once you begin an interview, you're allowed to stop or terminate that interview at any time. Do you understand? This is your client. You have a right to have an examining trial. You have a right, if you're not a citizen, you have a right to have your consulate contacted. You have a right, with regards to a court-appointed attorney, they're going to determine if you qualify for a court-appointed attorney or not. So what will end up happening is there's a document that you will fill out, and it's a document about your finances to see if you can afford an attorney. If it's determined that you can't afford an attorney, then one will be appointed to you, and you will have suitable time to consult or speak with your attorney. Do you understand?
Okay.
And the document that you fill out to determine whether or not you're eligible for a court-appointed attorney, you have to swear to that. Do you understand?
Yes, ma'am.
Right. Once an attorney is appointed to represent you, that attorney will contact you by the next business day. So if you receive your court-appointed today and it is 11:39 a.m., they'll need to contact you the next day by 11:39 a.m. Do you understand?
Yes, ma'am.
All right. Do you understand these rights that I've just explained to you?
Yes, ma'am.
All right. Do you wish to have be interviewed for a court-appointed attorney? Or do you wish to? Okay. All right. So I'm going to have you sign this document, and the document that you're signing is not an admission to any crime or the admission of guilt to this offense. It's just an acknowledgement by you that I've gone over these rights with you and you understand them. Do you understand?
Yes, ma'am.
All right.
Your Honor, if I may address the court.
Yes.
First, I get two things, Judge. One, public counsel and I have spoken, we've agreed to a $5,000 bond on this case, which would mirror the other bonds that he has on the other two cases. And then as the court appointed, I guess he's going to go through I just want to make sure I'm clear from my own information. I've been appointed on the other two. Will I not automatically be appointed on the third, or do you want him to go through the process before
You'll have to speak to the court coordinator about whether or not you can be placed on this case as well. It makes sense that you will be placed on this case. And if you'll talk to the court coordinator, I'm sure that Judge Nahara will hear your bond issues today since he's in custody.
Okay, so well, you had asked us earlier about an agreed bond and we have an agreed bond, so.
All right.
I didn't know if you were willing to take that up now or not.
You'll need to take it to Judge Nahara. Thank you. All right, you're welcome. Anyone else who's ready, the same rules apply. Just have your file placed up here and the court will take it up. So far, the persons I have are Rosales, but we need an interpreter. The other person is John Carlos Cisneros Armstrong.
I'll get the interpreter before I give you the file.
Okay.
Interpreter online as
All right,
well.
thank you. Sure.
Mr. Rios' side.
Your Honor, may I approach?
Yes,
Judge, I represent Martin Rios.
I don't have that file. The two files I have are Leonardo Rosales and John Carlo Armstrong.
Your Honor, if it please the court, I've asked that that file be put before the court on.
All right,
three
as soon
occasions
as,
today already.
all right, as soon as they put it up here, I will take it up. Could someone put that file up here, please? All right, where's your client?
Mr. Rios?
All right, state.
State's ready on this case, Your Honor.
All right, you're coming back tomorrow for jury trial. Sign the reset form. We'll see you tomorrow at 9 a.m.
Thank you, Your Honor.
You're welcome. Hello.
How about them tags?
We are trying.
Hey, it started out rough. But
Oh, my gosh.
So I was thinking about you because I had heard some rumors that you went back home for a short period of time.
Mhm. Yes, yeah. You know, things always get better. Oh, you're supposed to be behind the line. That's okay.
Where's the deputy when you-
Yeah. All right. But thank you for that. I appreciate it.
No problem, Judge. Judge,
It's on the docket today?
no.
Okay.
What I was going to ask for is if you could have that recall for next Thursday. I'm going to be in Oklahoma till Wednesday.
Oh, what are you doing in Oklahoma?
Just going to see my dad again
Oh, okay.
to do his things he needs to do.
Oh, no, I understand. Are you in contact with your client to let them know?
Absolutely. Absolutely. She also has a pending NIMAC case that has not been indicted.
Okay. So,
Yeah, just to move till Thursday, that's all.
so are you saying Thursday, September 28th or a different date?
September 28th, just 2 days later.
All right. All right, if you'll give that to Ms. Ferguson so she can put it on the docket. Thanks. You're welcome. It's always good seeing you guys. I miss you guys. I would see you guys all the time on CPS, but don't see you guys that much here. Is it? No, not this semester, because I have things I have to take care of in Louisiana.
Oh.
Yeah. But so do you still wait a long time where you have a case set at 1:30 and you're there till 4:30 or 5? Or has it changed?
A little better now they have the other judge.
Yeah.
Just process.
Because now they have 3, right?
Right.
Oh, that's good.
Oh, it helps, but they filed fewer cases, so.
Yeah.
262 is married to one person.
Oh, that is so great.
Tuesday afternoon where you don't have to be 27, you don't have to be here 5 o'clock waiting for a 3:30.
Oh, my gosh. That is awesome. But you know who I miss? Judge Schubel.
Oh, yeah, I do too.
He would have his and it would be quick. He'd be like, so what's the problem? Yeah. Status quo, status quo, status quo. Thank you.
Yeah.
All right. All right, you guys too. Have a good one. Oh, well, you know, the courtroom down the hallway, because I didn't want to move because it's expensive for the county to move. But my restroom wasn't working. The heat was horrible. All of the technology started failing. There was a flood. The flood from the DA's office that year, it all flooded down to our courtroom. Furniture was damaged. And I had people to come in and say, oh, the carpet is fine. And I said, the furniture was damaged. They didn't test with readings or anything. And it would always, when we come back from being at home on the weekend, when we come back on Monday, you could smell the mold and the dampness. And so I told them to fix the carpet. They never would. And guess what? We leave. And then I said, I walked there. I'm like, who gave them new carpet?
Of course.
Yeah.
Good seeing.
All right, you too. Have a good one. Immigration? Yes. Sure. What are you approaching on?
Yeah, this is it. I'm just waiting for them to bring it.
All right, Leonardo Rosales. All right, family violence, this is your case. All right, are you all ready for jury trial?
Yes, ma'am.
And I'm assuming he's already spoken to immigration, is that correct?
Yes, ma'am. I'm providing.
Okay. All right, this is coming back for jury trial tomorrow.
Thank you.
And if you'll get a reset form from Ms. Ferguson, she will give you your reset form.
Will do, Judge. Thank you.
All right, thank you.
Excuse.
Yes, once he signs the reset form. All right, and we have one more for you. It's always great seeing you. Who's here on Edgar Aguilar? All right, if you'll come forward.
I'll step in for the CPR.
All right, thank you. All right, so this case is not actually set for jury trial. What is the status on the immigration? Because the last thing I had was that he had a private immigration attorney.
I haven't actually discussed that with him today, Your Honor. What I have done with him today is extended the plea bargain offer that the state has made. He has rejected it and says that he does want to set it for a jury trial. I believe he is a resident, is that correct?
Yes. All right, we're going to go on the record. Are you ready, Dinah? Court is calling 2023 CR 4709, State of Texas versus Edgar Hernandez Aguilar. Could I have parties announced for the record for the state?
Brittany Mitchell for the state. Megan Enriquez, present for John Coons for Edgar Aguilar.
Are you Edgar Aguilar?
Yes.
All right, we have an interpreter here. If you could raise your right hand. Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Norma Nero.
All right. Mr. Aguilar, do you have any objections to this attorney standing in for Mr. Coons?
No.
All right. Counsel, the court has that on its note on the docket sheet that the defendant has a private immigration attorney. Is that correct?
Yes, Your Honor. I did reach out to that attorney after the last setting. I hadn't heard back. However, notwithstanding the immigration issue, the state has made him a plea bargain offer. He is currently rejecting the plea bargain offer and would like a jury trial. So I think that he is a resident, just from what I.
Well, let's do one thing at a time. So the first thing, does he have a private immigration attorney?
Yes.
All right. Do you mind if I put your client under oath to ask the questions as it relates to his immigration attorney?
No problem at all. Your
All
Honor.
right. And I will not go into any attorney-client privilege. Mr. Aguilar, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Do you have a private immigration attorney?
Yes.
What is that immigration attorney's name?
Ramirez Garcia. Your Honor, I believe he's stating the name of the firm. Yes.
All right, so that's the name of the firm?
Yes.
So you have hired or retained one of the attorneys at that firm to address any immigration issues you have?
Yes.
And that's any immigration issues as it relates to these two charges? Has he made them aware of these two pending charges?
Not to my knowledge, Your Honor.
No.
They,
Oh.
can I ask him?
Yes.
This firm, Ramirez and Garcia, has represented you in obtaining documentation in the past, correct? Yes. To your knowledge, your ex-wife has not contacted them to make them aware of these criminal charges.
No.
No. And so they have not advised you on how these criminal charges could affect your immigration status or your residency. No. And your ex-wife has not paid them any additional money to advise you on these criminal charges at this time? No. Do you plan to use a private attorney to advise you on how a criminal charge could affect your residency? Or would you like the court to appoint an attorney, an immigration attorney, to advise you on how this would affect your immigration status?
puedo después hablar atrás. Después puedo ver esto, hablar con mi abogado.
Can I talk about this with my attorney?
All right, this
Later.
is what I'm going to do. I'm going to reset this for 30 days. Counsel, are you appointed?
Yes, Your Honor.
All right, I'm going to have an immigration attorney appointed. And Mr. Aguilar, if it turns out that your wife or you wish to hire another immigration attorney, you're more than welcome to do so. But I don't want us to get to the point where we're at a jury trial and then it's, I need an immigration attorney. So, Ms. Ferguson, on this case, I'm going to need a 30-day reset. I'm going to need an immigration attorney appointed. And once that immigration attorney has reviewed everything and given him advice, then I will do a quick turnaround for a plea deadline date.
Understood, Your Honor.
All right.
I can do October 24th.
All right, so we're going to be back on October 24th. And Norma, if you'll let Mac know that he needs an immigration attorney and if you'll stay on top of that, counsel.
Yes, Your Honor.
All right, is there anything else?
Nothing further at this time from the defense.
All right, thank you.
Thank you, Your Honor.
May I be excused?
Yes, thank you so much. And Diana, we'll take a break as soon as things arrive. All right, are the attorneys here on Fidel Ayala?
Yes, Your Honor.
Good morning. All right, this is set for jury trial.
Monica Gadetto's ready. I believe the state's ready as well.
All right, we're recalling it for tomorrow at 9 a.m.
Yes, Judge. Do we need a reset form or? we-
Yes, get the reset form from Ms. Ferguson.
All right, thank you, Judge.
You're welcome. Norma Ayala is coming back tomorrow for trial. Are the parties here on John Carlos Cisneros Armstrong, the attorney?
I don't know if he's coming back today. He might.
Okay.
come back today.
All right. Who's here on Alexander Leonard Williams?
Morning, Judge. We're present.
All right, thank you. Mr. Cabanas, it seems you're always in our court for trial, maybe. Where's your client?
He's in custody, Judge.
All right, come on down, Mr. Williams. All right, so where are we on this case?
Judge, we're ready.
Okay, and state which case would you be trying?
We'd be proceeding on the ag assault deadly weapon, Your Honor.
All right, we will see you tomorrow dressed for trial. All right. Is that a Greek symbol on your arm or something else happened?
Oh, that's something else happened. Yeah.
Okay, all right. All right, we're gonna come back on the 20th and you'll be dressed in trial in that outfit. Unless there's something else you wish to come to court attired in. If it is, then your counsel will have to make sure that happens. Counsel, if there's an issue with the clothing exchange, just let the court know.
Yes, Your Honor.
All right, is there anything else?
Just 9 a.m. tomorrow, Judge?
Yes,
Thank you, Judge.
you're welcome. Please can go back. All right, anyone else who's ready, you need to approach the clerk and ask them to pull your file. Otherwise, your case is not getting called. Briella Butler. Briella Butler.
Yes, Briella. That's right.
All right, why is she late? She needs to sit on the front row.
We have the victims up there.
Ah, well, if you can put her on the front row over here.
But you were late this morning. And so as soon as it's-
Brandon Sierra. Thank you. All right, are you all ready for jury trial?
Good morning, Judge. I am ready for the next 3 days. However, I have a special setting, Judge, in Waco, on Monday, the 25th. I just don't think the trial would be finished by Friday.
Oh, it will.
Okay.
We'll stay here.
But
We'll
wanted
stay
to
here
make
late if we
sure,
need to be.
Because it's been set for more than 90 days out. So
Okay.
I've cleared 2 whole weeks because there's about 8 victims on that case.
Oh, Hank, this is family violence. All right, we'll be back on September 20th. Just get a reset form and then you're excused. So how was your trip? I love seeing your photos.
Oh, yes, that was in August, right?
Yeah.
It was really nice. I'd never been to the islands out in Spain. So, yeah, it was more than I expected.
See, I'm gonna have to call you because there are some different places I want to visit that I haven't visited yet.
Yes.
I don't swim though, but I figure I can put my toes in the water.
Yes, well, when we went out in the boat, because I didn't go diving this time, you know, some people didn't go out in the water because, you know, they would stop at some swimming places for, you know, half an hour or something. But still, it's just lovely, the drive out there. Right?
Yeah.
You know. So, yeah, there's other places that I learned of to go maybe next at some point.
Okay, awesome. I'm gonna call you.
Yes, do.
All right, she'll give you the reset form and then you're excused.
Thank you, Judge.
You're welcome. Okay, Juan Ross is here. Briella Butler. Could I see that file on Briella Butler, please? Oh, is she Briella Butler?
Yes.
Ah, just a moment. Can you call Umberto Saldana and tell him he needs to be here?
Recall for today, but I think it's entering the system for October 19th. We have an agreement with the state. Can you give a name for a team?
And where is Nathan Slimane?
I conferred with him this morning, Judge.
All right, let's see if we can get Mr. Slimane back here. And we need Nifa Carrillo and Elizabeth Russell. Oh, okay. And just let me review things with Maldonado, then we'll take it up. Who's here on Thomas Reyes?
Kevin Curiel, so Judge, on that particular day.
Is he on the docket today?
They're not on the docket, they're on the docket next Thursday.
Mhm.
I'm out of town and I was just wondering if we could bump him to the 10-3 or 10-6 or 10-13, you know. Or whatever date in the future, but those are just
All right, so what's the date that they're scheduled for?
9/28,
And you can't be here on the 28th.
correct.
All right. Are you here on the 25th or any of those dates or no?
I'm-
And are you able to get in touch with your client? Are they in custody or no?
No, they're not in custody, so. Yeah, 9:25 on Monday, that would be fine.
All right, and are you able to get in touch with them to
I
be
think I
here?
can get in touch with both, so 9:25.
All right, yeah, Norma, on these two cases, Reyes, if you'll recall that for 9:25. And I'll give you the files. So it's Reyes and Kevin Curiel. All right. Thank you, Hank.
Thank you, Judge.
You're welcome. And this was the other one for 9:25. All right, Briella Butler. We're gonna call you back at 1:30. Yes. All right, Bashan, that just put a smile on my face. All right, Norma, were you able to get in touch with Elizabeth Russell? All right, let me see the file on Todd Dotson. Is he out here? Mr. Dotson, if you'll come down, please. Your attorney's not here. They're running late. So we're going to recall you tomorrow. You scheduled tomorrow for jury trial. All right. Is there anything, was the clothing exchange okay? Were there any complications? All right, so we're going to bring you back tomorrow for trial, okay? All right, thank you for your patience.
Thank you.
And what is happening with Nifa's case?
Judge, I got hired on it, Judge.
Ah, okay,
So I'm waiting for an interpreter so that I can approach.
okay. All right, thank you. Is your client a citizen or no?
No, Judge, that's what I need to approach.
All right, could I see the file on Luis Ramirez Rodriguez, please? Ah, so supposedly Mac has already been appointed for immigration issues.
And so we need to, I don't think he's had that interview yet.
Okay. Just give us a moment. And Norma, can you remember to get in touch with Mac and ask them if they have issues where they don't have enough immigration attorneys, just let us know and we can appoint different immigration attorneys. And counsel will take up your matter in just a moment.
Yeah.
And Norma, I'm gonna need a 30-day reset on Mr. Ramirez Rodriguez. It's gonna be for the immigration issue. Okay. Okay, we can do a barbecue plate sale to afford a massaging chair.
Your Honor, the interpreter's here.
All right, let's proceed. Norma, you're back. All right, Mr. Ramirez, if you'll come down. All right, why is he in a dirty shirt?
Because of the beating.
All right. No, I mean, he doesn't have any clothing at the jail?
That's what they gave me.
Judge, that's what he was arrested with, so I'll make arrangements next time to do an exchange.
Okay. All right. So my understanding is that you've just been recently hired?
Yes, Judge. The last setting, I was just hired that day. And then we, as you said off record, that we got somebody assigned to him to do a Padilla letter. That I conferred with him. And he has not seen anybody yet.
All right. Ms. Ferguson, can you ask them if they have a backlog with immigration, the MAC? All right. So what we're going to do, if at the next setting you still haven't spoken to an immigration attorney, we can pull another one that's not for MAC. If there are not any objections, counsel.
Yes, ma'am.
All right. So we're going to come back on October 24th. And hopefully at that time, immigration attorney will have a chance to speak with you. And the other thing, counsel, make sure that your notice of retained counsel is filed, because on the docket sheet, they still have Ms. Carrillo as the attorney.
Yes, Judge, I'll refile it. I did file it, but apparently.
All right, and we do have forms back there that you can fill out. Yes.
Okay, I'll do that right now.
All right, is there anything else?
No, Your Honor.
And state, I don't believe they're ready to confer about the actual case until the immigration issue is solved.
Yes, ma'am.
All right, thank you.
Thank you,
We'll
Judge.
see you back on the 24th.
Thank you.
You're welcome. And that's October 24th.
May I be excused? Your Honor?
Yes, thank you very much.
Anybody needs an interpreter?
Let me see. Anyone else need an interpreter? No, you're in high demand. All right, everyone, I'm going to take a 5-minute break. And could
Yeah.
Okay, y'all appreciate that. All right, everyone, we're going to take a recess so that the court reporter can have a break. We're going to come back at 1 and we're going to finish everything at 1. So if everybody can be back here at 1 and State, if you will call Mr. Cox and Miss Efron and have them come back, please.
During the break room, they just text me.
All right.
Not in the break room.
All right, so we're going to come back at 1 o'clock, everyone. And then we're going to take